In this video, we'll discuss question number 7. What is antecedent debt? Discuss the powers of Hindu father to alienate to co-partitionary property for payment of its antecedent debt. So now we'll exactly define what is antecedent debt. The very word antecedent debt as used in Hindu law implies two things. One is antecedent in time, and the second one antecedent in fact, in nature. That is to say, the debt must be truly independent of and not part of transactions impeached. And Lord Dunden defined the very word antecedent debt as antecedent in fact as well as in time, that is not a part of the transactions impeached in the leading case, Brish Narayan versus Mangal Pandit in 1924, in the very decision on by the Privy Council, the antecedent debt to pay off, in which an alienation of the joint property is made, must be antecedent in fact as well as in time. The debt must be truly independent and not part of the transactions impeached, and it was held by the Allahabad High Court in the leading case Babulal versus Chandrika Prasad in 1977. The very significance of antecedent debt lies in the fact that the father of a Hindu joint family has been given the right to sell or mortgage the joint family property, including the son's interest therein, to discharge antecedent debts. For example, a debt which has been contracted prior to such sale or alienation, both in point of fact and time. That is to say, the debt must be truly independent of and not part of the transaction impeached. A sale of joint family property which is made to discharge a debt taken at the very time or as a part of the sale transaction is not valid because the debt in this case is not an antecedent debt. And in the very leading case, in Narayan Prabhu versus Janardhan Malan in 1974, the Kerala High Court held that in absence of a plea that the debt for the discharge of which a Hindu father has alienated the ancestral property was vitiated by illegality or immorality of the debt, the sale is not liable to be challenged if it is shown that it has been executed for the discharge of antecedent debt of the father. So also in Catholic Church versus Vishal Kumar in 1990, the Jammu Kashmir High Court held that it is a well settled proposition of law that if the alienation is shown to have been made by the father for payment of an antecedent debts incurred by him, the son can still get rid of it provided he is able to prove that the debt was tainted with illegality or immorality. So, the very burden of proof of immorality or illegality lies on the son to prove that the debts were tainted with immorality or illegality. This burden is not discharged by showing that the father lived an extravagant and immoral life. A distinction, connection between the debts and the alleged immorality must be proved. In cases where the father dies before the decree against him has been fully satisfied, it may be executed by attachment and sale of the illegal or immoral purpose as provided under Section 53 of the Civil Procedure Code. Objection of the sons as to debt being tainted with immorality or illegality should be determined in execution and not by a separate suit. If the sons contend that there was really no debt, the question is to be decided in a separate suit. Since time-bound debt cannot be recovered, the sons are under no pious obligation to pay their father's time-bound debts, but an agreement to pay even a time-bound debt is valid as provided under Section 25, subsection 3 of Indian Contract Act. Hence, where a time-bound debt is renewed by a fresh agreement, the whole of the joint family property would be liable for it, including the son's interest therein. As the Hindu law does not recognize any rule of limitation for the recovery of debt, so the time-bound debt is not immoral but can constitute a valid antecedent debt within the meaning of Hindu law. Hence, an alienation to pay a time-bound debt is valid and binding also on the sons as it was decided in the leading case Gajadhar versus Jagannath by the federal bench in 1946 of the British time. So now exactly we have to find out what are the moral, immoral, and illegal expenses that were brought under the debt and which are considered as unlawful. So, such debts due for spirituous liquors, debts due for lust, debts due for gambling, unpaid fines, unpaid tolls, useless gifts or promises without consideration, promises made under the influence of lust, commercial debts, any debt which is immoral as equivalent to a debt for a cause of repugnant to good morals, so the surety debts, and all these are falling under unlawful debt which are immoral in nature. So, the son is not liable for such debts, and if those debts are antecedent debts, then the father has the power to alienate to the coercionary property of the coercionary interest of the sons regarding payment of the antecedent debt